Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Just realized that today is actually 2 years since we had our very first. We weren't even had episodes or anything back then, but I had brought in Chris here to join our class. I think we had Skype at one point. We were using speakerphones and making it work there because I guess Teams and Zoom and all the technology wasn't ready for the post-pandemic or the post world before the pandemic transition there. And we've come quite a long way 2 years later. I think we've had close to 500 people, close to 300 of these recordings available. And I thought it was a great time to reconnect here with Mr. Sewrattan and talk about his practice again and some of the other things that we didn't capture both last year and in 2020. So, Chris, thanks again for joining us. And perhaps you can tell us a little bit more about what you're up to, the road leading to where you are today.
Thanks. Well, thanks for having me. I am a lawyer at Sewrattan Criminal Lawyers, which just consists of me and my sister, Ashley Sewrattan. We do criminal trials and appeals at all levels of court, including the Supreme Court of Canada. I'm in my just about to finish my 10th year as a criminal lawyer, and I've only ever been a criminal lawyer. For a brief period of time, I was also an adjudicator at the License Appeals Tribunal, where I adjudicated matters relating to the SABs, statutory accident benefits. And I also took a break at one point and went back to school and did my master's. Other than that, part-time I lecture at Lincoln Alexander School of Law, which is at Ryerson, otherwise known as X University, and I teach criminal procedure.
Okay, perfect. So let's start in with, I guess, criminal law. And right now, my students just finished talking about bail and bail hearings. And I know you had worked on a case a few years ago there that I think even after our textbooks came out. So maybe you can tell us a little bit about the bail process to start with and how people can be, what are the grounds in which they can be detained and how all that works in terms of looking at being released and the process.
Right. So the police can arrest you if they have reasonable and probable grounds to believe that you committed an offense. And what that amounts to is probability-based credibility. So basically, is there enough, more than a hunch, to believe that you are the person that's committed something? If they do have that, they can arrest you, and then they can decide to either release you with no conditions, release you with some conditions, and that's a document called an undertaking, or to not release you and to hold you for bail, which they'll call a show cause hearing. If they decide to hold you, then they relinquish the power over whether you stay in jail or not. And that gets transferred first to the Crown attorney and then ultimately to the bail judge, which can be most often is a justice of the peace and sometimes can be an actual judge. In terms of the Crown can decide whether to consent to your release, and then in which case you'll be released automatically with conditions, or they cannot and contest the bail. And in that situation, there's a full-blown bail hearing where the Crown, generally speaking, needs to prove why you should be detained. And if they fail to discharge their onus, then you will be released with or without conditions by a judge or a justice of the peace.
Okay, perfect. So let me start with what are the reasons why the Crown would be opposing your release and how you can be detained further.
Right. So the Crown will often oppose release if you are, for example, already on bail, right? So you have a bail condition saying don't possess guns because you were charged with a gun offense, and the cops find you with another gun. The Crown's going to oppose it. Or if you've committed the offense in the past. So if you were charged with drinking, if you were convicted of drinking and driving, and you shortly thereafter you're out there doing it again, that might be a reason to oppose bail. Or if there's no one to supervise you. But one thing to keep in mind that is actually often lost in court, and it was something the Supreme Court's tried to drive home recently, is that although practically speaking, whether you get out instantly or not turns on whether the Crown consents, it's actually you who needs to consent. Because generally speaking, the presumption is the Crown has to prove why you should be detained. And so when the Crown says that they consent, what they're really saying is, I acknowledge that I can't prove why you should be detained. And therefore, I concede that you should be released because I can't meet the burden that's put before me. And it's actually you who consents. And often that's really why cases are going to the Supreme Court these days, because forget lay people, judges are forgetting that.
And that's interesting, I guess, because we always look at it as the Crown is giving you that permission, but inherently you have that, you're presumed to be innocent. And sometimes we get this issues, politicized, right, where someone's out on bail and then they commit another offense, and we're like, oh, our bail system is broken, how can we let people out? So maybe you could talk more about kind of how that works and expand more on what you were just saying.
Right. So there's only three criteria to determine if a person should be detained. And if those criteria, if any one of them doesn't apply, then you have to be released. Right? So those criteria are whether you'll attend court as required. That's called the primary ground. 2, the secondary ground, whether you will, your release will pose a risk to public safety or the administration of justice. And we call, that's generally about whether will you cause harm to other people. And 3 is whether your detention is necessary to maintain public confidence in the administration of justice. So what will people think? And that's called the tertiary ground. And if it doesn't fit into those buckets, you have to go. So for example, if you are a person who has never been arrested before, but the judge thinks, you know what, if they put you on a curfew, you might not be able to obey your curfew. That in and of itself is not enough to detain you, because it doesn't mean you won't attend court. It doesn't mean the public's going to lose confidence in the administration of justice. And it doesn't mean that you're a threat to public safety, right? It means you might breach your bail, but it has no actual effect on public safety. And that's another mistake people are making.
Now, with the tertiary ground, I mean, what really rises to the level of, the public confidence in the administration of justice? Maybe you can give some examples to students who kind of, how do you know, is it because it's a serious charge, or what do they look at? What are some of the criteria they look at to kind of break that down a little further?
Right. I do wish I had researched this before we spoke, because I'm going off the top of my head. But it's in the criminal code. It's section 515, I think sub 10, sub C. And Parliament, they say Parliament writes the criminal code. And the criminal code says, consider all the circumstances. But it also delineates 4 that the judge has to consider in particular. So those are always the easiest to consider. And off the top of my head, it's the severity of the offense, whether the circumstances of the offense, including whether a firearm was used, the severity of the penalty, and I can't remember the rest. Oh, whether you're subject to a lengthy term of imprisonment, and the strength of the Crown's case. And of those 4, the one that matters the most, they say none of them matters the most, but practically speaking, it's the Crown's case, strength. Because even if you're going to go to jail forever, it doesn't matter unless the Crown can prove it, right? So a weak Crown case often gives rise to the tertiary ground not applying. And that's when you see politicians jump up and say the bail system's broken, right? You see that with serious murder cases. I mean, all murder cases are serious, but charged ones, like when that Toronto police officer was run over at Nathan Phillips Square, right? And you see like someone kills a cop and you expect them to be detained until their trial, but they get released and everyone wonders why. And I don't know why, but the answer probably is that it's a weak Crown case.
And I guess obviously then you go back to the presumption of innocence, right? At that stage, it's not that the trial hasn't been run, even whatever evidence has come up at the bail hearing, it's not the full case at that point. So you can't kind of assume there's going to be a finding of guilt, right?
That's right. A central theme in criminal law that's never really talked about is it's about humility, right? Because it's been going on through the English system for hundreds of years. And they've learned some lessons and they try to implement it so you don't make the same mistake twice. So humility means that's why you have guilt beyond a reasonable doubt. Because we as the justice system realize judges can get it wrong. So you can't punish someone unless you're really sure. That's also the presumption of innocence. We assume you didn't do anything wrong because we know we've gotten it wrong in the past. And that's also why you have a right to bail. You have a right to not be detained while awaiting trial because we've learned that the system can be wrong. And so it's wrong to hold you for something that you may not have done. And just to give you an actual example, JP, the last murder case I did was one that did make the news. It was 3 people charged with shooting this 14-year-old child in a drug deal. And there was video of it. It was all over the news that this kid gets into the car and then he runs right out 5 seconds later and he dies right there on the camera. And I went for bail. My client went for bail through me twice and was detained both times because, you know, they're alleged to have murdered a child. But this is where the strength of the Crown's case really comes into play in terms of her criteria for the public interest ground, because not only was my client acquitted of murder, there's a test that your students may learn about called a preliminary inquiry, where it's the opposite of guilt beyond a reasonable doubt. It's if there's any evidence at all that can convict this guy, then he gets committed to trial. But if there's absolutely no evidence, then he can't. And the judge found that there was absolutely no evidence, right? And so he spent almost a year in jail, and he had 3 kids. He spent almost a year in jail during COVID for something that he was absolutely innocent of, and something that the Crown had no evidence of, all because the judge wanted to maintain confidence in the administration of justice.
And certainly you don't get that time back, and there's not much real recourse, right? I mean, which is why you would tend to want to, to err on the side of caution, I guess, right, in terms of bail, right, at that stage, given the presumption of innocence.
That's right. And just in case any of your students are wondering, you can't bank that time. So it's not like he can go punch someone in the face and use the 11 months that he had toward that future sentence. It's just time lost.
Now, one of the other things there is, usually when you're trying to either negotiate there with the Crown or through a judge's decision, right, is typically there may be some conditions, right? You may have sureties involved. And I know you'd worked on ANTIC, right? And maybe you can tell us a bit about what that means and how that whole process from least restrictive to most restrictive, that being imprisonment, would work.
Right. I represented, along with another lawyer, the Criminal Lawyers Association in this case at the Supreme Court. It's called ANTIC. And what that case now stands for the proposition of is that when someone is before a bail court, the judge has to understand that the presumption is to release this person unconditionally with the lowest possible use of restraint. That's where you start. And if you want to go anything above that, you need to justify it step by step. Because what people were doing, and they're still doing, is, someone gets charged with something serious, like gunpoint robbery, and the judge is already considering whether they should detain him or her. And if they're going to release them, whether, they need an ankle bracelet or something. And ANTIC was a reminder to court to say, slow down. You don't jump to the maximum type of restriction, because the right to bail means the right to bail on reasonable terms. So you start from the lowest restriction and you work your way up step by step. In terms of actual, like what ANTIC actually was, it was just this guy who happened to live in Windsor. He was a drug dealer. And so he had ties to the States. And so the judge was like, you're a drug dealer. I think you might flee. I think you're releasable, but I need you to put some money down, drop some money with me so that I know that you won't flee because you won't want to lose that money. And the Supreme Court was really upset. That's why they took the case and said, that's too, you don't start with that. You start with, is this guy releasable on the lowest restrictive condition? And if you had done that, you would have never asked for money. And here we are.
Now, I know you mentioned, obviously, you've spent a number of years at different colleges and now at the Lincoln Alexander School of Law, and you're teaching criminal procedures there. Could you tell us a bit kind of what you cover and what that's been like in that experience?
Yeah, criminal procedure, I think, is what everyone thinks criminal law is. in terms of like substantive law. So it's all of your charter rights, all of your legal charter rights. So your right to bail, which we're discussing now, your right against unreasonable search and seizure, your right against arbitrary detention, equality rights, things like that. And then it's also more fundamental criminal law proceedings like the preliminary inquiry, which we just spoke about, sentencing, jury trials, things like that.
So another aspect there, I'm glad you brought up the charter, right? Maybe you could tell us a little bit more about how charter rights come into play in criminal matters and how that affects, if someone may be factually guilty, but there may have been a breach of their charter rights.
Right. You don't understand the charter in terms of criminal law. It's just a remedy. So it doesn't actually protect anything, practically speaking. And what I mean by that is, you have a right against unreasonable search and seizure. Well, right now, there's a relatively new law. I don't remember the name. It might be Cannabis Act, but it allows the cops to search your vehicle if they think you have improperly stored cannabis in your vehicle. And nobody knows if that law is legal or not, if it's constitutional. And in fact, one judge has says it's not. Well, if you're driving around and a cop searches your car pursuant to that law, you can't just be like, wait, show them a judgment, and they're not going to stop. What's going to happen is they're going to search your car, and if they find something criminal, you'll be charged. And then at your criminal trial, when you're staring down the barrel of jail time, you'll have the chance to raise the fact that the law that the cop relied on wasn't constitutional. And if you're right, your only remedy would be that you don't go to jail and you'll be acquitted.
And then I guess in terms of practicality, right, that how do you kind of go about making those submissions there? If your client says, hey, this happened to me, I want to attack this law, it's not fair. How does that go about, and how does the court determine whether or not it is constitutional or unconstitutional?
The Canadian Charter of Rights and Freedoms was enacted in 1982. So if my math is right, we're up on 40 years. I actually think it was in April. So, there'll be some ceremony, I'm sure, 40 years of the charter. Anyway, the point is, each of the provisions in the charter, largely speaking, have had the opportunity to formulate their own tests over time. So for every single charter right, there's a test. So if you believe that your charter rights have been violated, or more likely your lawyer does, the lawyer can check the appropriate test and see if it applies to you.
And I guess maybe you can switch a little bit here. Now, every time we talk about different areas and different aspects of criminal law. But I did want to talk about, I know you're very active on Twitter and as well, involved with the CLA's Canada's Court podcast there. And, we're always looking at sharing for my students, especially. I know a lot of them tune in quite regularly and post about it. But maybe you could tell us a bit about how all those things came about and the importance of kind of sharing information there with on Twitter, for example, there with the audience that you do have.
Right. So in terms of Twitter, I was like everyone else. I just got Twitter because people were telling me to. And then I used to retweet stuff. And then I realized it was aimless. But what I do, because I do criminal appeals, every day since 2010, I have read the Court of Appeals website. And I only read the criminal judgments. But someone told me to do it. They said it would be good to learn. They were right. And I was doing it anyway. And I always had these thoughts about these cases, but I never, besides talking to my colleagues at the office, I never had a way to express it. And a lot of them made me mad. I always disagreed with the court. So I was like, okay, let's make Twitter constructive. And so I just started tweeting about cases, and nobody liked them. There was no feedback on it. But I was like, you know what? If I'm going to keep Twitter, to keep my own views in check and not, make an ass of myself, I will only tweet about one thing. And I'm only going to tweet the cases that I read. And so that's how it started. And then I got a lot of a lot for me is 2,000, but I got a lot of followers. And now I get a lot of feedback, people debate and engage with my tweets substantively, academically. And I appreciate feedback from anyone, but in particular, I have law professors across the country who will either tweet at me or DM me about the tweets. Um, without naming names, I've had many judges tell me that they look at my tweets and that they have burner accounts or whatever. So it's been flattering and it's been interesting. And so something for your students to take home is, what's your niche going to be, right? All I did was take an outlet that is recreational, but I just turned it into something productive by just putting to paper or putting to keyboard what I was doing anyway. And I encourage anyone watching this to find yours and do that. In terms of Canada's court, that's a podcast presented by the Criminal Lawyers Association that is just the audio of the Supreme Court of Canada's criminal hearings. And they have an introduction at the start that is said by a Criminal Lawyers Association member. The idea, I created the podcast in terms of I had the idea. It's administered by an excellent production team that works for the Criminal Lawyers Association. So there's a team of men and women behind it who actually produce it and combine the audio and all that. But the idea itself, I got from the States. They have something called the OYEZ. OYEZ. I think it's presented by Cornell University. And it's just the straight audio of the US Supreme Court. There's no introduction. So if you don't know anything about the case, it's a bit tough to follow. So I wanted to do that, but the Supreme Court, unlike the OYEZ in the States, you can reproduce the Supreme Court's audio all you want. But in Canada, the Supreme Court Act, I believe it's the Supreme Court Act, regulates who can use their audio. So you can't just take it off their website. You need to license it. And to my knowledge, they had never granted a license before to use their audio or video. So I applied right when COVID hit, and it took a year for them to okay it. But in 2021, in the summer, they okayed it. And we've been playing catch up since, trying to get the audio from the hearings from the day they okayed it to now. And we're about, this week, there were, I think, 4 or 5 hearings in the 5-day week. And we have everything set that we could probably produce all of them next week. So we're getting better with our backlog. And yeah, I encourage anyone to listen to it. They're interesting, but they're also instant smart pills. You listen to a hearing because you have the introduction, you'll know what the hearing's about, and by the end of it, you'll know the governing law.
That's great, and certainly there on both aspects, right? It's sharing that and getting that engagement, and certainly the people that are listening get a chance, right, to kind of have a little bit as you sort of difference from the United States, right, is that there's a little bit of that introduction, so you may now be able to go ahead and listen and kind of get an understanding. And maybe you could talk more a bit about the importance there, especially for students to you said, look, find your niche. How kind of you got that advice from others, right, that have provided mentorship to you, and and especially in criminal law, the importance of having that mentorship, paying it forward. What students can do to kind of approach, or who they can approach and get kind of more guidance, and if they want to get into criminal law or to do things like that.
Yeah, you have to have a mentor to make it in criminal law, just because there's so much to learn and there's so much you can do wrong with very high stakes. So that's the need. The way to go about it, I think, is just to be a little brave and just approach people digitally in this COVID era. So LinkedIn, emails, Twitter, what have you. Email, contact criminal lawyers and ask them if you can shadow them, if they're taking people for hire, or if they just have a time, you can talk to them and bounce ideas off of them. Criminal lawyers are very friendly. They'll generally give you the time because someone gave them the time, like me, down the road. In terms of myself, I was lucky. I established my mentors through school. My mentors also happened to be my professors, and then they hired me to article, and then introduced me to other lawyers who then hired me, and I've just kind of branched out from there.
Okay, so now I want to switch gears because we've talked a bit about criminal, and I do want to talk about something that you did, for a while there, and especially because next week my students that are doing tribunal practice, we're going to learn about the license appeal tribunal. So, how did that kind of come about? Because it's completely different than criminal law, and maybe you could tell us a little bit about the tribunal and what that experience was like.
Right. In terms of how I got it, it's interesting. perfectly dovetails with the last statement, which is to, try things, like reach out, um, be brave. What I was doing was I was completing my master's of law, and I was starting my own law firm. And in between that, there was a lag, and I was bored. So I was just on the Ontario, I think it was in the Ontario reports, but I saw it on the Ontario government website that they had applications for appointments, and it was to some tribunal. And I was like, what do I have to lose? So I applied, and it took them like 7 or 8 months. I didn't even, when they responded to me, I had no idea what they were even talking about. But I figured, what, can't hurt. I'll come for an interview. And when I showed up, I remember you had to write a test, and the test was like about accident benefits. I've only ever done criminal. I had no idea what they were talking about, but I was like, whatever, I'll figure it out. So I wrote it in, and then I had to do a bunch of interviews, and I eventually got appointed. And so that's how I got in. In terms of the tribunal, so it's changed a bit because now all tribunals are under the umbrella of Tribunals Ontario. But once you get in and into a tribunal, you get down to the fact that if you are in a car accident, obviously everyone knows you can sue the person that you've hit if you feel that there's cause. But in addition, you have car insurance, and your car insurance is supposed to give you certain benefits, right? So every car accident entitles you to, with some exceptions, $3,500 of accident benefit. And that $3,500 can go towards counseling, if for the trauma, physiotherapy for the physical trauma, things like that. And then if you have a certain level of injury, you can go to $50,000. And if it's a catastrophic injury, you can go to $1 or $2 million, depending on your insurance policy. Now, it's not so easy. Like any insurance company, they don't just give you the money if you ask for it. Sometimes they'll dispute it. And so rather than going through the courts in Ontario, they funnel all those to the License Appeal Tribunal to be more efficient, where you don't get full-blown court proceedings, but rather, at best, you'll get a hearing in front of one or more License Appeal Tribunal adjudicators.
And so typically, maybe you can tell us a bit about the process then. So I would imagine that it's more so on the side of the claimant that are saying I should be entitled to these benefits and I'm not getting them. How does it go from there, and how would it arrive before you at the lot?
Right. So what happens is, the claimant makes the claim. So what happens, the person that gets in the accident asks for the benefit, right? And the insurance company will write them back a letter and say, no, we're denying you. It's very formal. We're denying you because of X, Y, Z reason. You have, it's been a while since I was on the tribunal, but you have a certain amount of months or days to appeal if you feel this is wrong. Then you file the application to appeal. So technically it's an appeal. And that triggers the License Appeal Tribunal process. And then you can it's designed to have people without counsel or paralegals, self-represented. But a lot of them are represented, and a lot of them are represented by paralegals because it's a lucrative market for paralegals to be in. And so they'd come in, and either them or their paralegal will have prepared a brief, basically, saying, here's the accident, here's my injury, here's the test for why I deserve the legal test, for why I deserve what I think I want. And so give it to me. And then the insurance company, through their counsel, will have a response. And because the insurance companies defend against so many of these claims, they have a whole legal department. So if you're a paralegal starting out and you're doing this, you're going to go up, generally speaking, against a lawyer whose only job is to defend against these. So they're expert in it. And it can be daunting, but I've seen some very good paralegal advocacy at the tribunal.
And is it like written hearings, or are they oral hearings, or were they? I mean, I know obviously it's maybe have changed since you were adjudicator, but how does that work? I mean, when you're sitting in, and how was that as well? I mean, kind of related is different position for you, right? I mean, you're used to being defense counsel, right? Now you're on the other side of the bench, let's say. How did that all look into to looking back at it? How was that different from being the one? I mean, did you ever feel like, oh, I could go and argue this now? Like, how was that?
So okay, there's a lot there. So just actually, maybe I didn't answer your last question either. So when you first start out, you don't go straight to a hearing. You do something called a case conference, right? And that's where the real action happens. It's yourself, so the claimant and their counsel, which would be one of your students, the insurance company's counsel and their adjuster. So it's basically like the person representing the insurance company, and they control the purse strings. And an adjudicator of the license appeal tribunal, but not necessarily the hearing adjudicator. And you talk, right? It's just mediation, and you try to come to an agreement. And the vast majority of cases resolve there. If things can't resolve, internally at the tribunal, we had a saying. It was not necessarily a hearing, but a hearing if necessary. And what that meant is the default hearing would be a written hearing. So you would write out your argument, attach your supporting documents, send it in. Same with the insurance company. An adjudicator would look at both, make a decision. The secondary option was hybrid. So especially if there was witnesses, like you say, oh, my back hurts and I go for physio and they're telling me I need more, maybe they'll cross-examine your physiotherapist, right? And that might be over the phone. And then the final option was a full-blown in-person hearing. You'd see those for catastrophic cases where the person is catastrophically injured and they're looking for $1 to $2 million. And what we used to do, we have a hearing office at right by Yonge and Dundas Square. But if it was elsewhere in the province, they would rent out a hotel conference room, and you would do a full-blown in-person hearing. Now, the second part of your question, how did I feel being on the other side? It was great because it improves your advocacy. And here's a helpful hint for your class. In any forum in which you're practicing law, look at the legal test that is going to be used to get you the thing that you want, right? So if you're saying, my client wants $50,000 for whatever, look at the legal test, spell it out, and tell the adjudicator why each part of the test is satisfied by you, right? Because if you just say, this person really hurts, they got in a car accident, their back aches, they're in pain all the time, $50,000, please. The adjudicator is going to say, well, I really feel for you, but let me look at the test. And if you don't meet it, I have no other power.
And then in terms of that, how was it writing decisions as well, right? You'd have to look at the laws that were argued or their interpretation and such, and then you'd have to come up with a decision. What was that piece like?
That was interesting because I knew nothing. I'm like your students. I knew nothing about what's called the SAB, Statutory Accident Benefit Schedule. So I read the schedule, and then I read a bunch of past decisions. And then I felt like I had a handle on it. And I did exactly what I just said. I would find the applicable test. First, you find the provision, write it out, see if it's been interpreted to have a test, write it out, take each part of the test and just see if and apply the evidence to that part. And you only stop when you either finish the test or if the evidence doesn't satisfy a certain part of the test. And I would just write that out. And then at the tribunal, as most tribunals are trying to be like, they don't want they're not the Court of Appeal. You're not the Supreme Court. You're not waxing or pontificating. You're just settling a dispute. So you try to write as briefly as possible.
And on that, one of the things that we have legal research in writing and legal communications in writing, and certainly we talk about oral advocacy. But what can you share in terms of writing? In that aspect, and as well, obviously on the other side where you're preparing FACTA and applications and such. Any tips there for students in getting all of that put together, improving their writing?
Yeah, I have quite a few. So it's actually all counterintuitive if you went to university. Because in university, they teach you big words and they teach you, cute sentence structures and all that. When it comes to legal writing, the simpler, the better, right? So if you can write the words simpler, the better, do write it. So the fundamental rule, I think, is put your point first, right? So you wouldn't say, if you were to describe a hamburger, you wouldn't say it has a bun, it has lettuce, it has tomatoes, therefore it's a hamburger. You should say, it's a hamburger, period. It has a bun, it has lettuce, it has tomatoes. Point first, and then you can backtrack and go to how you got to that point. Makes it so much clearer. And I do this for all my writing. If there's a sentence, you read it and you can cut off a word, or you can cut off a syllable by making it a smaller word, do that. If you can turn a sentence into two sentences by cutting it in half, do that. The simpler the sentence, the shorter the sentence, the better. And that's also why I was tweeting so much, because once I went to the tribunal and they kind of like make you unlearn all the fancy words and fancy writing, they really drill home plain language writing, then the tweets became easier, right? Because you back then I was in 128 characters. It becomes so much easier when you just write for like, I think of my dad or my brother, like, just write for something for them to understand.
I was going to say shots fired at Alex there, but uh, what I mean, so I mean, thinking back now, I mean, you've had time there, working as as a professor there, going back in school there. Anything else there for students? I mean, we're looking as obviously transitioning back, and I would imagine, I don't know what it was like this semester or maybe the fall semester. I mean, comparing your time in person versus remotely. I think you might have had a little bit of both experiences over the years. What can you share kind of in both aspects there from a academic purpose, and then I guess later we'll look at as the courts return from that purpose. So let's start with the school first.
In terms of school, if you're going to go all the way to school during COVID, do the readings, or just don't go. Because the people that go to class and actually engage, and you can tell they know what they're talking about, form a much stronger impression than those who don't. In terms of online, it's tough, right? Because especially in paralegal school or law school, half the benefit to you in doing it is networking, because it is through your networks that you will obtain a job, that you will obtain work, client referrals. And so if you're doing it online, I think you should try as much as possible to connect with your colleagues socially, even if it's just video conferences or whatever, because that is probably more valuable than the grades you get.
And then let's look at it from then practice point, right? I mean, I know I've had different defense counsel, especially all over the place, on whether Zoom trials and attacking credibility, if that's a good thing, bad thing. I mean, now that it looks like we're going to have far more options about what the next steps can be, and you can have more things in person. What was those experiences like, and what can you share from doing something in person versus doing something remotely, or was there a difference in your mind?
There's certainly a difference. In terms of cross-examination, it still should be in person. There's a certain, I mean, your students got to go to class to see it, but when you have a witness on the stand and you catch them in even a small lie, it is very tense. It's uncomfortable for them. And there's nowhere to go, and they're in a foreign room. You can cut the tension with a knife, and that's lost on Zoom, especially when internet connections are bad and stuff. So it's not the same. That said, I do a lot of appeals, and you talk charter arguments, stuff where it's just straight up legal argument. That stuff is what Zoom is built for. It's great, and I hope that that kind of advocacy continues.
Perfect. And in terms of appeals, I mean, that's something, again, different there, right? In terms of whether it's crafting your written arguments, or we were just talking about writing and doing it on Zoom, or even in person before. What's sort of the difference there when you are taking on a matter that's an appeal versus when you have something that is going to go to a trial? How does that, in terms of your preparation for an appeal, what do you do, what goes into it, and what do you want to, as you mentioned up the legal test there right before, what goes into how you prepare for an appeal? I mean, whether it's going to the Ontario Court of Appeal or potentially the Supreme Court, what are some kind of tips there for anyone, or just kind of interested in how that goes?
Appeals are harder in terms of academics. They're difficult, and they're a lot of work, but I actually find them a lot easier than trials, because you don't create evidence on an appeal. You just argue from the trial's evidence. So there's a record, there's no surprises, right? It might be 10,000 pages, but if you read all 10,000 and you're smart enough, you know what's in there. Whereas with the trial, the witness might say anything and you have no idea what to expect. So with an appeal, you just know your record really well. And then the other thing is, when you do a trial, your judge or jury is hearing this stuff for the first time, whereas you probably spent months preparing for it. You know everything about the case. but you kind of got to, there's a bit of theater here. You got to tell them a story. On an appeal, the judge read the same thing you read. They know everything. So I say good morning and stuff. That's it. And I launch directly into it. Don't go over facts. Don't go over anything. Just straight up legal analysis. And it's more to the point and comfortable. That said, if you're going to do criminal law and you're going to do criminal law at a high level, so at the Court of Appeal or Supreme Court, it's a rough ride. The judges are, I wouldn't say they're mean, but they can be harsh, and you have to be prepared for that. And this is a plug for Canada's Court podcast. Go listen to it. Go listen to those judges just go off on the lawyers, and they know they're being recorded nationally. They don't care. And at the Court of Appeal, they're not recorded. I mean, they're not published in their recordings. So you got to get ready for that as well.
Perfect. So, Chris, thanks again. I think you're one of the few 3-time guests here I guess we're starting our 3rd year now. And certainly really appreciate hearing from you and hearing all the different things you've been doing over the years. Any final words of wisdom for everyone here listening, especially those who want to get into criminal law, or even I'm sure you have lots of students over the years too yourself who come and ask you, Chris, I really enjoyed, criminal procedure. I see myself wanting to get into this one day. What can you share? And again, thanks for joining us.
Yeah, thanks for having me. I'll say this. Look, this is not automatically true. This is just my opinion. But if you want to practice criminal law, don't be a paralegal. Go to law school, become a lawyer, and become a paralegal, or become a criminal lawyer. Just because the range of offenses that you can deal with are so small. Otherwise, you're just doing traffic offenses or prosecuting traffic offenses. That said, being a paralegal can be a great job, I think, if you look at other areas like immigration or the tribunal, stuff like that. And the second thing is, I know many paralegals who have become paralegals and then gone to law school and become excellent lawyers. And by excellent lawyers, I mean, top of their law school, the cream of the crop. So I would explore a career as a paralegal, but if you find that it's not enough, don't be afraid of going to law school and trying to make that happen.
Perfect. So thanks, Chris. Thanks again for joining us here. All the best there, and enjoy your weekend. And thanks for everyone for tuning in. And we'll see you back as we look to go on for another year and have hundreds and hundreds of more guests like Chris joining us. And thanks again for support, and take care, everyone.